I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today we are on number 259 on our compilation list. For this compilation, we will be in two different judges' courtrooms. Before I give you those names, don't forget, as you have been doing tremendously, is like, comment, share, and subscribe. I have been loving all of the comments and the support and the encouragement on the channel, the things that was going on with my mom, all of those things has truly been a blessing. I appreciate you guys for that. Also, there will be commentary added to these proceedings and chapters will be added for your convenience. It's only two proceedings, but if you feel the need to jump from one to the other, the chapters will be in there. Now, the two judges' courtrooms we will be in. First, we will be in the courtroom of Judge Demetria Trujillo or Trujillo, hopefully I'm pronouncing it either way correctly. And she is out of the state of Colorado. And second, we will be in the courtroom of Judge Erane Washington out of the state of Michigan. And for that Judge Erane Washington video, it was a proceeding that we shared about a year ago that you guys really got into just because of what the proceeding was about and just how the sovereign citizen was acting, the back and forth between her and the lawyers. So I'm sure you guys are gonna have a lot to say about it, especially those of you that have never seen it. Now, let's go ahead and jump into number 259.
Is number 42, Mr. Neely III.
Yes, Neely the third, and it's self-represented, not pro se.
Okay, one moment, sir. Okay, this is 25 CR 6861, People versus James Neely.
Kristen Lilly for the people.
It's James Curtis Neely the third for.
Okay. I do show Sean McCarthy's on this, but you're representing yourself. Is that correct, sir?
Awarded self-representation by the state.
Okay, we're just going to remove Mr. McCarthy as attorney of record and note.
And can you remove any of his filings? For I've never been served with any copies of any of his filings.
I can't remove filings from the court record, but I can remove him as attorney of record so that any filings will go directly to you, okay? I suppose we should make sure that we have an accurate contact information for you. Let me see, do we? Okay. Yeah, I wouldn't say it on the record because it's being broadcast. So
Yeah, recordings of proceedings for the Chautauqua Charter. I know it's.
no, but I just mean it's like being broadcast over the internet. But we'll get your updated mailing address. That means, sir, that any pleadings that people file and or any orders the court issues will then go directly to you. Okay, sir?
And there's the first bond that was issued. Polygraph.
Okay. What are we doing today?
Your Honor, just a little bit of background on this case. Mr. Neely III's cases have been pending in the preliminary hearing courtroom for quite some time. We did go to preliminary hearing at the last court date. The case was, of course, bound over. This is his first appearance in district court. I have spoken with Mr. Neely a few times. Our conversations, candidly, we've not made a lot of progress. I would just ask the court inquire of Mr. Neely if he would like a continued arraignment to continue, if you'd be interested in hearing a plea offer and discussing that with us. If he is just interested in pleading not guilty and setting for trial, that is an option as well.
For arraignment, the plea of innocent remains.
Sorry, I can't hear you.
Plea of innocent remains for arraignment.
Okay, so a couple things. You have a couple options today. One is to continue the arraignment, which just means you're putting off entering a plea of any kind. Or the other option would be to, because we're at the arraignment stage, you can enter a plea of guilty or not guilty. Those are your options.
This is more than the first time that we've been in this district court. For once, you've already tried to argue competency where I was awarded self-representation and competent to stand trial. Now, this is an arraignment 188 days after the arrest. I'm still waiting for the original arrest warrant to be issued. As you said, my name was James Neely on the file. The bond says James C. Neely. Yet again, another deceased person, James Neely, is not the full legal name. Neely III, James Curtis, should be what it is on the appearance bond. As you wrote here in pen that you said you would update it, so it would say James Curtis Neely III.
Mr. Neely, I need you to talk to me, not to the people. I'm trying to figure out what you wanted to do today.
You just argued that we tried to speak outside the courtroom and stuff like that, and it goes nowhere. So this is compromised by the compromise that I was trying to tell you about back.
Mr. Neely, talk to me. What would you like to do today?
Plea of innocent remains.
Would you like to plead not guilty?
No.
You would like to plead innocent?
Innocent, yes.
Okay, I'm going to treat that as a not guilty plea. It's substantially the same.
That is by you.
Okay, so I'm going to accept and enter the not guilty plea. I'll make a finding that speedy trial is, thank you, December 25th, but because that's a holiday, I'll make a finding that speedy trial is December 28th of this year. Sir, the next step after a not guilty plea enters is to set a few court dates and set deadlines for the filing of motions. Do you know whether you'll be filing motions?
I have filed multiple motions, multiple writings while I was in jail since December 20th, from the original charge from when it happened on December 20th for the assault on a peace officer. I have speedy trial in. The county already told me 6 months. That was back in January when she first tried to argue competency. Now it's 188 days today after already serving over 90 days in jail prior to my bond. That is way past speedy trial, December 25th.
Okay, I'm not sure if you're raising the issue that there's been a violation of your speedy trial, but to the extent that you are raising that, I'm going to deny it. The speedy trial clock begins ticking once you enter your not guilty plea. That just happened right now, and I've set your speedy trial deadline. So we'll set a jury trial date within speedy trial. But right now, my question for you is, do you anticipate filing any additional motions?
Correct.
You do, okay.
Yeah.
Does 21 days, is that enough time for you to get your motions filed?
Yeah, a restorative motion right now being filed for all my writings since December 20th.
I'm sorry, I didn't hear that last part.
A restorative motion since December 20th, since the arraignment.
A restorative motion?
Yes.
Okay, you'll have to do that in written form, sir. But
It's in writing within the county already. Everything should already went back to the state and then it went to the district. So now the district clerk should have everything on file as we originally started.
So, Mr. Neely, all the things that you filed previously, the Judge Moses has already issued orders on those. So those are deemed completed. I'm going to set a deadline. If you have additional motions that you want to file, the parties have 21 days to file those motions. The deadline for filing those motions is July 16. Does that work for the people?
It does, thank you.
Does that work for you, Mr. Neely?
Matters of practice and of other courts, may I have all of records that they have? I have yet to receive any denial of any of those motions.
I think you can go to the clerk's office downstairs and request documents from your court file.
I have already. They said they're giving me the runaround.
What did they say?
From the district clerk to the actual county clerk, they say I'm getting the runaround by you.
By what? The district court clerk's office told you that the DA was giving you the runaround?
Yes.
Okay, I don't know where that's coming from. The clerk's office has the record, the court record in this case. The district attorney doesn't have anything to do with the court record. So if you want documents from the court record, then you need to go to the district court clerk's office. I don't know if maybe you're talking about discovery. Has he picked up discovery?
He has. We did bring his discovery at the last court date, the preliminary hearing. So Mr. should have all of the paper and discovery and discs.
Okay.
That was served to him in 3H by the DA's office.
Are you talking about missing discovery or are you talking about court documents?
Discovery from the state.
What do you believe you're missing?
The term felonious is, you put somebody in a hospital or you harm them in a manner of such. So I'm waiting for all of the officers' hospital records, fingerprint IDs that allow you to identify a person or his other persons if it's a, organization or anything like that. That's what I'm waiting on.
Okay, are there medical records?
Fingerprints, medical records, experiments, photographs, testimony, disposition of all
Hold on, sir.
witnesses.
And Your Honor, this is an assault on a peace officer charge. The basis of the charge is that Mr. Neely applied physical force. There is no allegation of SBI. We do not have to prove SBI. I do not believe the deputy received any medical treatment, so there are no medical records.
Can
Okay,
I have a copy of the original warrant for arrest for holding?
you can go to the clerk's office. That's a document that's contained within the clerk's office, if there is one. I don't know if it was a PC statement or an arrest warrant. All the documents in the court file, sir, you can get from the district court clerk's office. Discovery is obtained by the district attorney's office, but those are two separate things.
Is this a state matter or a local matter?
You're charged in state court.
So the state clerk should have all evidence
The
then, correct?
district court clerk's office has the court record. The Denver district attorney's office has discovery.
Court record. And then is there any recordings of proceedings in this matter?
Well, everything's being recorded. If you'd like to order a
Outside of the courtroom?
outside of the courtroom,
Yes.
not that I'm aware of.
No telecommunications, no infrared, no license plate, no Axon
Sorry,
database?
sir, Mr. Neely, if you're talking about discovery, so if you believe that there's information in discovery, meaning police reports, anything related to the investigation of the case, you can make a request for
Time
discovery.
and date, yes.
But you have to identify specifically what it is that you think exists. You can make the request of the fee,
Specifically, no.
and
I'm
then,
not the one you guys are the ones using this evidence against me. So whatever evidence you guys have against me, I'm allowed to see, right?
yes.
Correct?
And I understand from the people that it's been
What I need from the
provided,
state then,
that it's been provided. And if additional discovery comes
full
in,
judicial records, not
The-
discovery, judicial record.
anything in the judicial record is contained in the court file.
Okay.
Okay. Anything further on that?
No.
Okay, so we're going to set a disposition date and a motions hearing date.
The defendant's presence must be there too.
Pardon me?
The defendant's present must be there for the disposition.
Yes, it'll be a condition of your bond.
Can I have a copy of that too, then?
A copy of what?
Bonds, the summons that you're issuing for the disposition?
I'm not issuing a summons. I'm going to continue your bond.
Can I have a copy of the actual bond and undertaking that you are going off of versus?
Again, that's contained in the court file. You can get it from the district court clerk's
Thank you.
office. For the setting of disposition, does July 23rd work?
I can accept that date.
Does that work for you, sir?
Yes, what time?
That'll be 8:30.
Probably won't be here till about between 9 and 9:30. Is that all right? Again,
We do July 30th. Well, we're going to set two dates. One is a disposition date and the other is a motions hearing date. And I'll tell you what those
Okay.
both are. I just want to get them set. Does that work for both parties?
I can accept those dates.
July 30th and July 31st at 8:30 a.m.
Well, I'm going to do 1:30 for both of those.
Sounds good to me.
Okay, disposition is scheduled for July 30th at 1:30 PM in 5D. Motions, if they proceed, will be July 31st at 1:30 in 5D. Sir, at this time, your bond's continued until both of those dates. On the disposition date, if you would like to accept a plea, you can do it on that date. You don't have to accept a plea. It's your decision.
Okay.
If you or the people have filed motions and there is no disposition on the 30th, then on the 31st at 1:30, the motions will be litigated. Does that make sense? Yes?
Disposition of the docket almost in a sense, yes.
I'm sorry, I can't hear you.
Close to disposition of the docket, yes, for journal entry, yes, I understand.
Okay, and you understand the motions will be litigated the following day if there is no disposition?
Well,
Yes, okay. Anything further on setting of those dates?
21 days,
21 days to file your motions. And I think it makes sense to go ahead and set the jury trial, but anything additional on the motions, dispo, filing deadlines?
Not from the people.
Does that have any reflection on 14 days to 28 days within any arguments or anything that I have within that motions?
I'm not sure.
July 31st. Well, 21 days usually you have, after the 28 days trial set and everything like that, 21 days, you have to file all your motions and everything like that for, pre-trial, everything, reciprocal discovery, everything like that, right? Correct. So then the additional, 8 days, they have to return any, filings or anything like that. So
The people, both parties can file a response to any motion that they want. There's no deadline for filing the response, but all initial motions have to be filed 21 days from today, and that deadline is July 16th.
So this is different from a pretrial order then?
Yes.
Okay.
Okay, anything further on those settings before we move to the jury trial?
Not from the people.
Just wanted to just stop here. A little quick intermission, guys. Couple of things. Mr. Neely definitely is a character. He tried to get into the little birth certificate thing briefly, but didn't really get a chance. The judge didn't allow him to really go into it. We see that it is a serious charge when it comes to the assault on the officer, but thankfully for him, the officer didn't go to the hospital, so it sounds like it wasn't that serious. But what I really wanted to ask you guys and have you guys chime in down in the comment section, you could pause it here at our intermission, is when he started talking about the clerk's office, do you think, three things I wanted to ask. Do you think that the clerk's office truly told him that, the prosecutors was holding out on him? Or do you think he made that up to try to create a little rift between the clerk's office and the prosecutor's office? Or do you think that he genuinely just mixed up what the clerk's office would provide and what discovery is? I just wanted to ask you guys that because I thought that was kind of interesting. And, we see the judge is trying to be patient with him. He's definitely asking a lot of questions. He seems like he really wants to know what's going on and be prepared. But most of the time, when you really listen to what he's saying, he still doesn't have understanding of a lot of things that's going on in the courtroom. But nonetheless, let's go ahead and jump back into the proceeding. Anything
more before we move to the next setting? Okay. All right. How long do the parties think for the jury trial?
I anticipate testimony shall be pretty quick. I believe the people would only be calling about 2 to 3 witnesses. I would be asking for a 4-day jury trial just out of an abundance of caution, timing-wise.
Let me see.
In this matter prior with the county courts, we already did disposition of what evidence that she presented, and I asked if there was any other witnesses on the list that she has within the documentation that she gave me. She declared no in the courtroom in front of the judge. She has one witness, and that is the detective who depicted what happened during those events.
So I'm assuming, sir, you're referring to the preliminary hearing when a witness was called?
Yeah.
Okay.
I asked for all witnesses to be there. They never showed.
Well, it's not required that all witnesses be at a preliminary hearing, but you do have a right to request witnesses of your own or issuance of subpoenas. I don't get the sense that you did that. Did you file a request for subpoenas?
I did actually CCTV from the jail versus body worn camera, without using their.
Sorry, subpoenas for testimony. Did you subpoena witnesses?
Did I?
Yes.
No, just the CCTV, just wanted the CCTV, that was it.
Okay.
The
There's a
circuit
process.
television that they have for security.
There's a process, sir, to request subpoenas issued by the court.
Yeah.
So I would encourage you to look at the rule, because you have to make a specific request of the court for the court to issue subpoenas, okay?
Well, yeah.
All right.
It's declared in their complaint security, so it automatically should be CCTV, video should already been entered.
The issue about how many witnesses the people call at the trial itself is not limited by the number of witnesses they called at preliminary hearing. There are requirements for disclosure of witnesses. The people are aware. You should be aware, sir. You have the same requirements for disclosure. But assuming those are all done timely, the people can determine how many witnesses they want to call at trial. Same for you.
Same disclosure for the employees of the jail.
I don't know who they're going to endorse, so I would just make sure that you keep an eye on any pleadings that might get filed, okay? Does August 24 or October 19 work for trial?
October.
I would prefer the October date, so.
Okay, we're going to set a 4-day jury trial for October, to begin October 19 of this year. How many jurors do you think?
I think, does the court have a standard panel number?
My standard panel, unless there's something kind of triggering, would be 45, but maybe 55 would be
I was thinking somewhere 55, 60, so.
60. Mr. Neely, do you think 60 jurors would be appropriate?
I'm not the one requesting the trial.
Okay, court will request 60 jurors. Mr. Neely, your bonds continued to all of those trial dates, and if it goes beyond the 4 days, your bonds could. I'm not going to set a pretrial conference at this time. I'm going to leave that till the disbone motions hearings date, and you guys can talk with Judge Moses about the setting of a pretrial conference. Does that work?
Judge Moses.
Judge Moses. So I'm just covering Judge Moses's docket today, but your case is assigned to 5D and Judge Moses, okay? That's when your bond returns are to that courtroom, okay?
Is there any additional thing that I would need to do for transcripts of prior courtrooms for this?
Yes, transcript requests have to be done on form. You can go to the clerk's office again. They can give you a copy of the transcript request form, and there are instructions on the form itself on how to make those requests. Okay, does that make sense?
Yeah, so what time? October 19th?
October 19th, 8:30, every day for trial, unless Judge Moses otherwise says differently, begins at 8:30. She doesn't start at 8 or something different, does she?
I think she starts
Normally it's at 8 a.m.
8:30.
the first day, every subsequent, for jury selection at 8:30 the subsequent days.
Okay, so I'm going to modify the bond return dates for October 19th. It's an 8 a.m. return date time. For the remainder of the trial, it's 8:30 unless Judge Moses says something different. Okay? Any questions on that? Okay, and then finally, I did receive, or the court did receive, a summons and complaint. Ms. Lilly, can I request that you approach? I did print a copy for Mr. Neely. Mr. Neely, I'm going to hand you a copy of what was filed in the court record. This was a filing made by Pretrial Services. Pretrial Services is the supervising agency regarding your bond.
The judge only declared on the bond as I have it written.
Hold on one second, sorry. I want you to see a copy of this. Have you already seen a copy?
Oh. Pretrial supervision was never stated in the courtroom by that judge.
Okay.
What were the conditions? On the bond that I have, there's no time and date for any of these court schedulings for pretrial services.
Is there someone from pretrial on for this case?
Good morning, Your Honor. This is Madeline with pretrial.
Thank you.
All right, sir, have you had a chance to review that summons and complaint?
Yes, they've asked to remove the pretrial services.
That is the request, as I understand it. I can tell you, I did confer with Judge Moses on this. The request is based on your non-compliance, but because you haven't picked up any new charges, Judge Moses, and through me, is going to deny the request. She wants you to remain on pretrial supervision, and she wants you to be checking in with pretrial.
Okay.
Those dates on that report were not court appearance dates. They were dates to appear with pretrial services.
Yeah, I'd never received any of those days before.
Okay, so what I'm going to ask, sir, is that you report to pretrial today. If you want to see, there's a card, there should be a card under there. Probably any of them. Sorry, under the podium, can someone help out?
Which one do you need, Judge? I apologize.
Anyone, I just need to give them the address to pretrial. Please make sure that you give them accurate contact information for you, because it sounds like they haven't been able to reach you.
Can't the court just update it?
No, you need to give it to them. And
I'm
you need,
convicted of anything. Why do I have to? I'm not trying to be rude or disrespectful or anything. I'm still understanding this whole probation part too. I just showed you the bond that I have. This is the bond that was issued. Would you like to read it? It has nothing to do from the judge about being on supervision.
sir, you don't need to talk to the DA, okay? I'm trying to explain it to you.
Okay.
The condition of bond was that you be supervised by pretrial services. That's contained in the court's record in county court when your bond was set. So those terms and conditions were set in the county court. One of the terms and conditions was supervision through pretrial services. It sounds like they don't have maybe good contact information for you because you've indicated you never got any notice of any of these dates. That's fine. To fix that, I'm going to order that you report to pretrial services today before you leave downtown. Please make sure that you give them current, accurate contact information so they can reach you going forward, and then comply with any other terms and conditions. Pretrial services can go over those terms and conditions with you again, because it sounds like you're saying you didn't have notice of those. All I can see is that those were ordered by the county court, okay?
Do you have an indictment from the county court then?
I think it was a complaint and information. It was not an
Still going
indictment.
off a complaint on
Am I
a
right?
felony
You're
offense
correct. It is a CNI.
or an 88 days
That
later?
didn't come with discovery,
Nope.
the CNI?
Hmm?
The CNI didn't come with the discovery?
It should have. He
I haven't
certainly would
received
have
one
the.
paper from the clerk.
Not the clerk, sir.
He should have a copy of the complainant information. It was also amended to reflect his name, Mr. James Curtis Neely III.
Okay.
And that was given to him.
Copy of that then?
Can I have you give that to him
Of
now?
course,
The
yeah.
original, and if there was an amended.
Of course.
So I will get you a copy, the DA will give you a copy of that here in the courtroom today. All other discovery you can obtain through the district attorney's office discovery process. Again, records contained in the court file can be obtained by the district, or I'm sorry, in the Denver District Court's clerk's office. And then terms and conditions of your pretrial supervision, you can go over with your pretrial supervising officer.
All filings have to be within the district clerk, you're telling me, correct?
I'm sorry, can't hear you.
All filings must be done in the district clerk's office, right?
Filings that go to the court, yes.
Service of copies then?
Pardon me?
Service of copies?
You
How
do
does that
need to
work?
serve a copy on the opposing party, yes. Was that your
Any of your
question?
filings, you must, if you have any of them that you're going to issue, can you please send me a copy? Just give it to the clerk.
That's why, sir, that's why we got your address.
The neutral part of, it's an Ohio address.
How are you going to get your mail?
Came out here to report my earnings and then this is what happens.
How are you going to get your mail if everything's being sent to Ohio?
I'll have to send it to me out here.
Who?
UPS, FedEx, do a destination drop off. Get a post office box or use a post office box.
Sir, we need to have some way to send you court orders. The DA needs some way to
Send them
send
to
you.
the address that I gave you. Just send them to the address that I gave you.
And that's Ohio, is that right? Okay. And you can get that address for us. It'll be updated in the court file, but we'll get it. You can grab it from us as well.
Okay, thank
Keep
you.
in mind, sir, if there's going to be a delay for something like that, if you're having your mail.
I'm in contact with the people that are there every day, almost.
Okay, let me finish. There's going to be a delay. If we issue a court order, or if the people make a filing, those will be mailed to the Ohio. So if that's going to cause a delay, you just need to be aware, because sometimes there are requirements for timely responses. If you do update your mailing address, you need to report that to both the court, pretrial services, and also to the people. You can file a notice of contact information change But until then, all pleadings and court orders will be going to that Ohio address, okay?
As soon as the mail gets there, I'll be notified.
Okay.
3 to 7 days, 3 to 10 days. It's normal.
3 to 10 is
Well,
quite a
it's 3
bit of
days
time.
within mailing, so you have 3 days regardless of wherever you go. If it's federal, I mean, you can go across. Yeah, see, that's not my full legal name. Yet again, you're trying this. James C. Neely. You have a copy of my birth certificate, James Curtis Neely III.
Okay,
Here is
sir,
the James C. Neely.
If you want to file a motion, you can file a motion.
And just to be clear, we did serve you with
Theft,
both
fraud,
the
forgery of a passport.
initial complaint as well as the amended complaint, and the amended complaint should have your correct name.
Okay, thank you, Ms.
I
Lynn.
have right here in her handwriting where it says
All right,
James Curtis Neely
pretrial,
III.
I'm sorry, Ms. Wilson, you didn't get a chance to speak. I'm just going to let you know Judge Moses wants him on pretrial services, so he should be coming to see you right after he leaves court today.
Thank you, Your Honor.
Thank you. Is there anything further?
Different case. Or...
Not from the people. Thank you, Your Honor.
Mr. Neely, is there anything else you wanted to address today?
She had him updated with the clerk, with the county.
Sorry?
The county judge, James Curtis Neely III, as my birth certificate and social security card read for full legal name of indictment. You're still going with this James C. Neely for a civil tort within Burns National against the surety of this bond for your Axon.
Is there anything further you wanted to address today, Mr. Neely?
Plea of innocent. That's it. That's it. I'll see you in July. How's that? Good?
Yes, thanks,
Off the
sir.
record, everything? We're off the record.
We're not off the record, but your
Walk
case
out of
is,
this room, I'm off the record, correct?
we're done with your case.
Yeah,
I don't
I'll
know
be
if-
off the record completely. This whole court
I
document.
don't know whether you're going to be on anyone's record, but you need to
So
report, you need to.
Flock Axon is not going to be, trying to do this whole license plate felony.
I have no idea, sir.
investigation or anything,
They may.
investigator?
They might.
Is that, are they going to be using Axon still? I'm going to need a warrant for that, for the telecommunications.
You can file a motion, sir.
I don't, they have to.
Okay. Go to pretrial. Okay, thank you.
Well, we're at the end of this proceeding. Before we jump into Judge Washington's courtroom, we see Mr. Neely. He definitely tried to put his sovereign citizen hat on and try to go into, the whole birth certificate thing and contract and whatever else he has said. But that mail situation, that may end up being a problem for him, because that's quite a ways away for him to wait on that mail and then hopefully get in touch with the people. But he says he can. So hopefully in the next proceeding, if we're able to get it, we don't hear him complaining about not getting the mail that he was supposed to get. But yeah, thank you guys for sitting in on this one. And listen, you're welcome to comment some more on this proceeding. I hope you guys commented on my first question earlier on in the proceeding. But now for this classic sovereign citizen proceeding out of Judge Washington's courtroom, let's go ahead and jump in.
All right, the court will call the case of the Ranches of Rosebrook versus A Nice Battle, case number 25C 1245.
Good afternoon, Your Honor. David Fanter on behalf of the plaintiff.
Ms. Battle, please hit *6, unmute your device. And state
Hello? Hello?
Please state.
It's a niece battle on a special appearance for the record to contest the jurisdiction and the facts before this court.
Yep. All right. Well, Ms. Battle, I'll tell you that this matter is appropriately in the correct court. The court does have jurisdiction.
And it's based on what? What is on the record that is based on that the court has jurisdiction?
The fact that this is a case that is within the jurisdiction of the Township of Ypsilanti, and if you have issues related to any contracts, that would be within this jurisdiction as well. So all of that is within the jurisdiction of this court.
So you're saying that the contract is in jurisdiction of the court?
That is what I just said, ma'am.
All right, and the contract has been rescinded. So how is the contract in the jurisdiction of the court if it's invalid?
individual gets to rescind a contract on their own. That's
What are you talking about? I have the right to
I'm
rescind
not
a
gonna
contract
argue with you,
by
Ms.
right of common law.
Ms.
That
Battle.
doesn't involve court.
Ma'am, you need to stop talking or you're gonna get held in contempt of court. Mr. Fantier, have you had a chance to talk to Ms. Battle? I talked to Ms.
You're breaking up. I can't hear you.
Mr. Fantera, do you need to speak with her or are we ready to?
If you want me to speak to her, I'll speak to her. You know, I mean, she talks about rescinding the contract. Does that mean she's moving out?
Ms. Battle, are you,
I'm sorry, you're breaking up.
are you moving out?
Are you moving out?
No. Why would I have to move out?
Because if you rescind a contract, okay, fine. Your Honor, I think let's set this for trial.
Okay. One moment.
This case has also been in the it's in the circuit court. A petition filed for an injunction. I did serve you all. It is set on the 30th.
Yes, ma'am, I heard.
We're aware.
Okay. And once again, I do not submit to the jurisdiction of the court. The contract is rescinded.
So how can the
And I am
contract,
not a legal person.
you're not a legal
How
person?
can a contract? No, I'm not a legal person. I'm not a legal entity. No, I am not. And you have to prove that on the record.
Stop talking.
Actually, I don't.
I'm sorry.
Can I ask Ms. Battle a question, Your Honor, real quick?
Sure.
So Ms. Battle, so you can live there forever without paying rent because you're not a legal person?
That's not what I'm saying, but the contract itself is invalid. I'm saying that you don't have any personal or subject matter jurisdiction over me. Over an invalid contract, no. And over me not having a legal capacity to be sued, yes. So if that's how you want to take it, then that's how you have to take it. But that's what's lawful and that's what's written in the law.
Let me just tell you, I think you're wrong on both counts. I would expect that we would.
It's okay for you to think that I'm wrong, but the facts still align with what I'm saying.
Okay, Your Honor, I think we should have a trial.
You have to prove without the reasonable doubt. So let the record show that the judge has not required the plaintiff to prove without a reasonable doubt that I am a legal person, and it's on the record, not assumed, not presumed, on the record. There's nothing that's on the record that states.
Ms. Battle, first of all, reasonable doubt is a standard in a criminal case, not a civil case. So I do not have to prove anything beyond a reasonable doubt.
I need both of you to stop talking, please. Both of you, I'm sorry. I cannot figure out the date because I can't hear over the two of you.
I apologize. I didn't know that's what you were doing, Your Honor.
This matter will be scheduled for May 6th at 3 p.m. for a trial on any and all issues that may be before the court. Ms. Battle, if you have anything else that you need to say, you can unmute yourself by hitting *6 to do that.
Okay, I just find it ironic that I got muted when I was speaking on jurisdiction and how there was a lack thereof on the record. So I want that to be on the record. But I also wanted to, okay, that's fine. And I also wanted to be on the record that I am not going to be able to show up on May the 6th. So it's also ironic that you are able to verify with him that he's able to show up, but not with myself.
I just asked you that, and you are now talking about something else. Why can't you do this?
That's because you cut me off and put me inside of a break room and muted my mic instead of allowing me to speak on what needs to be spoken on.
All right, this is set for May 6th at 3.
Your Honor, by Zoom? By Zoom?
Correct.
All right. Thank you, Your Honor.
It's ridiculous. This is a fraud upon the court. Goodbye.
Well, guys, we've come to the end of the first appearance for Miss Battle. We heard her challenging jurisdiction. You know, some of the same things we've heard in the past. She talked about rescinding the contract, which is something that she cannot do. But also, you know, the attorney, you know, I applaud him for asking her a great question. You know, listen, even if you do believe you are not the legal person or the legal entity, does that mean that you can just stay here rent free and not pay any rent? And, you know, she answered that with, no, that's not what I'm saying. But the bottom line is you haven't been paying your rent. And that's why we're here. That's what the issue is. But also, you know, it seems like when it comes to Miss Battle, in her mind, there's like a huge conspiracy going on here. And I talked about this in the last video. I'm not saying every courtroom does things right, and that sometimes people aren't conspiring against the defendant. It wouldn't be the first time we heard it, wouldn't be the last. But I think some of these things that she feels is a conspiracy isn't. Like when she got muted because she just kept talking and wouldn't stop. It wasn't because it was a conspiracy of her talking, against her because she started talking about jurisdiction or that they were afraid for that to be on the record. But anyway, there's another appearance. That was a pretty short appearance. Let's see how this next appearance goes. I'm interested in seeing it and see if she comes back with a new argument, and see how Judge Washington handles it. Excuse me. So let's go ahead and jump into this proceeding.
Good afternoon. The 14B District Court is now in session. My name is Erane Washington, and I'm the judge that will be presiding over this session. The court will call the matter of the Ranchers of Rosebrook versus Anise Battle, case number 25C-1245.
Good afternoon, Your Honor. David Fantera on behalf of the plaintiff.
Ms. Battle, could you please state your name? Battle. I'm sorry, could you repeat that?
My name is Denise Battle.
Thank you so much, Ms. Battle. All right, today's the day and time scheduled for a hearing in this matter. This is an action to terminate the tenancy based on non-payment of rent.
Yes, Your Honor. I object to these proceedings moving forward because, like I said, I do have a verified petition and emergency motion for injunction in the U.S. District Court, which is the case number 25-CV-11233.
Thank you, Ms. Battle.
And like I said, this court has not put on the record their jurisdiction. There's nothing on the record and it stands. Every notice that I've sent is unrebutted, which stands at law. And jurisdiction is a threshold issue that we shouldn't even made it this far without discussing proper jurisdiction.
All right. Anything else, Ms. Battle?
As of right now, no.
Okay, thank you.
But I object to these proceedings in jurisdiction, subject matter and personal.
All right, your objection is noted for the record. Ms. Battle, I've already ruled on jurisdiction when we were here last time. We will be proceeding today. The court does have jurisdiction. Mr. Fantera, and Ms. Battle, do either of you have...
I object. The court cannot declare its own jurisdiction to respond.
If you keep interrupting me, ma'am, you're going to get held in contempt of court, and the court does have contempt powers while you're in jail.
I interrupted you. Okay, that's all.
Your Honor, I want to point out also that Judge Vandenberg actually addressed this issue last Wednesday and said that the 14B District Court and Your Honor does have jurisdiction over this matter. So not that it needed to
May I add, Your Honor? Yeah. She also said that she was not aware of the things going on. So she just went on for anything based on what he just said. To shed any law nor facts, just as you don't, of why you have jurisdiction. And it's no order that has it back yet, to be clear.
All right, thank you. Again, Ms. Battle, this court has jurisdiction and we will be proceeding today. Mr. Fantera, actually the both of you have an opportunity at this time to do any opening argument that you want to make. So Mr. Fantera, I will start with you. Do you have an opening statement?
I'll waive my opening statement, Your Honor, and just get right to the evidence.
All right. With respect to service, can you please put on the proofs regarding the service in case there is an appeal?
Say that again, Your Honor.
Can you please put on proofs regarding service in the event that there is an appeal?
Mean service of this lawsuit?
Yes, on Ms. Battle.
I believe that she was served by a court officer with Jimmy Moore's office, Your Honor. I think there's a proof of service in the file. I don't know whether it was attached or whether it was personally served. but the court has the proof of service.
With respect to proof of service, the file indicates that Ms. Battle was served with 2 different ways pursuant to MCR 4.201B, which is she was served, actually 3 different ways. She was served with an original mailing from the court, and then a second mailing went out from the court. Second mailing was requested by the plaintiff and was sent by this court. On March 28th, there was a mailing. And then there was service by Edward Cope, who was the court officer. That service was effectuated through securing an attachment to the main entrance of the tenant's dwelling unit. And that was done on April 4th, 2025. And after attempts had been made on April 2nd at 12:40, and then April 3rd at 9:53, they finally did an attachment on April 4th at 4:30 p.m. In addition to that, Ms. Battle showed up to the court on April 9th, 2025 before the magistrate, therefore acknowledging that she had received service in this matter and that service had been perfected. Right. With respect to jurisdiction, we addressed that at the last court hearing. This is in Russell Court, which is within the jurisdiction of Ypsilanti Township. I think we hung up.
Your Honor, when she comes back, can we require her to, she appeared the last 2 times with a video. Can we require her to have video today?
Ms. Battle, are you back?
Yeah, we were disconnected.
Yes, Ms. Battle, you're back. All right,
Yeah.
what request were you making, Mr. Fantier?
I know the last 2 times that Ms. Battle has appeared, she appeared with a video, and this time she's just on her phone. Can we require her to be here by video today also?
I would have had to give
Well,
her.
the thing is like I tried to tell you all last time that the time was bad. This is when I pick up my kids.
All
So
right,
we can do it like earlier or something of that nature. Yeah, that's fine.
Then I'm okay just proceeding as long as the court is comfortable that we can swear her in when she goes to testify.
Thank you. I am comfortable. I can tell you that if I was going to require that she be here via video, I would need to give her notice of that prior to today's date. So I'm comfortable proceeding as we are.
Okay.
All right, and Ms. Battle, other than jurisdiction which has been noted and reserved, do you have any other argument you want to make today with respect to this matter in terms of an opening argument?
Of course. So, like I said, the contract has been rescinded on April 1st, and it was due to unconscionable pieces in the contract, including pieces that's wrong with the formation. As well as material breaches that's inside the contract. That contract has not been.
You said material
breaches.
Oh, okay, go ahead.
Breaches, yes, within the contract as well. That was sent out and received. Well, it actually wasn't received on April 1st because at the end of the day, the unconscionable pieces, their addresses are wrong and the owners are wrong on the contract, so it got sent back. But once I realized it was received on April 8th, 2015 and still remains unrebutted. They have yet to unrebut it in any case that we've came and talked about the contract. And by law, according to Wall versus Zendaya, the Michigan law recognizes rescissions at common law for breach, fraud, and unconscionability. Meaning, if I give notice and it's unrebutted, that stands at law. Also, I've talked on personal matter jurisdiction, in which why I came in under special appearance the first two hearings, because at the end of the day, I'm not a legal person. I'm not in a legal capacity under Michigan law. I do not qualify as that person, which that person is a corporation, a trust, individual, in some type of legal entity of that nature, an association. I do not qualify as one of those people to be here and subjected to this without consent. Hence why, things were sent administratively and defaults were given administratively, because things are happening right here where I'm being deprived of due process, and I should be awarded due process by law. As the attorney stated last time we were here, he was saying that basically the burden of proof only applies in criminal cases, which is false, because the burden of proof applies in all civil cases where jurisdiction or contract validity challenged, and that's Taylor versus Bullam in 1992 in Michigan. You still have the burden of proof. The court cannot establish their own jurisdiction being based on a contract is rescinded. You have to have a valid contract to come into court about. So that's where your jurisdiction of the subject matter is at hand, because the contract is rescinded. Not unilaterally, like he's tried to claim before. It is rescinded, meaning I gave you notice and it's unrebutted, just as if somebody came into the courtroom for an eviction, or if they did not come for the eviction, you'll give them a default. Because what happens at law, your silence stands.
All right, thank you, Ms. Battle. Mr. Fantera, you may proceed with your case.
Plaintiff would like to call Dawn Charles as a witness.
All right, Ms. Charles, please raise your right hand to be sworn. You swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing?
I do.
Thank you. You may lower your hand. You may proceed.
Ms. Charles, please state your name for the record.
Dawn Charles.
And what is your position with the Ranches of Rosebrook?
I'm the property manager.
Are you familiar with the tenancy of Anise Battle?
I am.
Are you familiar with the lease agreement that that she signed?
I am.
Your Honor, I submitted to the court a lease agreement dated November 12, 2024. I'd be moving for that to be admitted as Plaintiff's Exhibit 1.
Did you also provide a copy to the defendant?
I did not, because I do not have her email address. But she should, Your Honor, I should say for the record, she should have a copy of the lease, because it is, because she signed it.
Any objection?
I never received a hard copy of the lease, and I've asked for a hard copy of the lease, never received it. And as I read the lease, that was also a breach of my lease, as I was supposed to receive it and sign it in person, as they made me sign it over online. So again, the information that he's saying about the lease is correct. I'm not here to argue about the lease. As far as what the original contract was, I'm arguing about the validity of what it is now, which is invalid and void because it's been rescinded.
Thank you.
And unrebutted.
All right, given that she's not arguing about the validity of the lease itself, I will allow the exhibit.
No, I did argue about the validity of the lease as far as it being valid, because it's not. But I'm not arguing that I entered into a lease on or around December 6th. That's not what I'm arguing. I'm arguing the validity of the lease. So let's correct that.
You're arguing, you're not arguing that you entered into the, what are you arguing?
Like I said, I do not object to actually entering into a lease. What I thought was, yes, a proper lease on or around December 6th. I do not deny that, but I do deny the validity of the lease because the lease has been rescinded and it's unconscionable. Yes.
Thank you. Her argument, as the objection in the case is that the lease is rescinded and therefore not allowed to be admitted. That overruled and it will be admitted.
Oh, 1 second. Y'all gotta. Everybody be quiet. I'm sorry, I didn't hear you, Judge.
I said that your argument that the lease is rescinded is not being admitted. The lease is admitted. That objection is overruled.
On what facts of law?
The fact that I just ruled that, ma'am.
That's not a fact or a law, so let the record show that she has no proof.
The record
no
shows
no
everything. The record shows everything, ma'am. You don't need to say that. Please stop.
I know, it will when I pull the transcript, because like I said, this case is also.
All right, Mr. Fantera, you may proceed.
Okay, I want the record to show that I find it unfair that you can cut me off and use my mic whenever you feel like it. But I can't talk and have a fair hearing.
You're going to be held in contempt of court and you're going to do jail time. Mr. Fantera, please proceed.
Ms. Charles, can you, under the terms of the lease, what is Ms. Battle's monthly rent?
$1,075.
$1,075?
Correct.
Does she also have to pay utilities?
Water and sewer.
So for what months has she not paid her rent?
March, April, and now May.
So she owes $1,075 for each of those 3 months.
Correct.
Has she, does she owe the water and sewer for those 3 months also?
Yes.
How much does she owe for those months?
Her water and sewer?
Yes.
So March is $36.24.
April?
$35.45.
May?
$35.73.
Okay. That totals $107.42, correct?
Correct.
Are there late fees under her lease?
There are.
What is the late fee?
$50.
On what day?
The 6th.
And so she's being charged a late fee for March and April, correct?
Correct.
So the total amount that she owes is $3,225 in rent, $107.42 in utilities, which is also rent, $100 in late fees, and then she would owe the court costs of this in this matter, correct?
Correct.
Have you reviewed the work orders that have been submitted by Ms. Battle since she has been a tenant?
Yes, I have.
Are you comfortable that they were all completed in a timely fashion?
Yes.
No further questions, Your Honor.
Thank you. Ms. Battle, do you have questions for Ms. Charles?
Yes, I do. So that the first working order, are you able to disclose, or do you know firsthand what that was?
Your first work order was your shower water wasn't hot. You had some screws in your hinges that weren't secure. And when the water was turned on in the tub, it comes out of the shower as well.
Okay. So how do you define complete? How is that work order complete?
Well, that was the work order you put in. The notes for repair are that the diverter for your hot water was repaired. Our construction company fixed the tub faucet that had came off, and we installed new screws in hinges on the door.
Right, so do you have anything that the actual construction company came because nobody came? Because even if you go on to the next 3 orders, that's also listed as an issue because it was never addressed.
Well, the next work order after that was actually December 26th, and it says the door that was repaired, the screws were still not right, so we put new screws in it, so that wasn't a work order about the tub. The one after that was January 28th, and that was about hearing animals in the attic, and we installed new soffit and made sure nothing was in there. There was also one on January 27th. We adjusted your shower head and plunged your toilet and tightened a basket on your sink. There was one on February 14th that your tub was not draining and water was coming out of the faucet. We unclogged the tub and the shower head was working properly. And the last one was March 17th that your furnace was cutting on and off. And we took your furnace apart and checked all the fuses and put it back together, and it was up and operating properly.
Okay, so let's go into that more, because we might even have to subpoena the maintenance man, because this is going to become an issue. So when you say that you came into my bathroom and screwed the shower head, what would be your purpose of doing that? Because what was my request? My request was that it was still, the water was still coming out of both faucets at the same time, which have not been correct because you have not gotten a contractor out here. A contractor has not came out to my house about that. And let's go on to the heat, right?
Miss Battle.
I'm sorry.
You can't testify now. You can ask her questions. You wouldn't get a chance.
Okay, contractor was in the apartment between December 15th and 16th because
wait a second. Wait, please stop.
Wait.
There's no question.
You said I had to form it as a question. I apologize.
Okay, go ahead, Ms. Battle.
Okay, so you're saying that a contractor came out, you said December 16th?
Correct.
And what contractor was that? The contractor that did the job?
Correct.
Okay, and when that contractor came out, what did they say that they did?
Repaired the tub faucet that had came off and repaired the tub diverter.
They repaired the what that came off?
The faucet for the tub.
One more time.
And the diverter for the water.
Right. Okay, so let that address that the faucet pushing out and the diverter, that doesn't address the issue of the plumbing, which really, when I had somebody come out, they said the wall has to be taken down because what happened is they messed up behind it. So again, let's rephrase, let's go on to the new one. Let's go on to the furnace. So when they came out for the furnace and they came out to fix it the first time, what were their results from that?
I only have one work order for your furnace. They took it apart, checked the fuse, put it back together, and it was up and running. They cleaned it and put it back together.
Okay.
The furnace is new.
So no, it was 2 work orders. One was done in the middle of the night. I'm in the morning before they came into work. So I just wanted to be clear. So you don't have that work order for the morning. I'm asking the question.
1 second, there's an objection.
Your Honor,
you said it was an objection?
Can you listen to it, Ms. Battle?
I can hear him now. You say he had an objection?
Your Honor, I want to object. We're getting into the weeds here. I mean, you don't have a right to withhold rent or rescind a lease because of something small such as a tub faucet. And so, we're getting into whether somebody actually came out and fixed it or when it got fixed. And it just seems to me that this is irrelevant to the proceeding that's going on today.
Well, it's object because it's not irrelevant to the proceeding because it's part of the reason on why I put out the brief. Because at the end of the day, I kept trying to get somebody to come out to fix these things that are not fixed. Heat is a major thing. It's been cold. I still have a heater in my house because they haven't came back and got it and fixed it like they said they were going to. You get what I'm saying? It's still unconscionable things in the lease regardless. So everything about what I am arguing here is valid because I do have the right to rescind the contract based on breaches of the contract, just like you can come here on the a quote unquote breach of the contract. It's the same thing. Why do I not get the same right and to hear what's going on so she can hear what's going on?
Your Honor, we will be more than happy. The purpose of rescission, as the court knows, is to put the parties back in the same position they were before the contract got entered into. We will be more than happy to rescind this contract and basically have Miss Battle pay what she owes through the date of move out and terminate it so she doesn't have any more rent owing after move out. The problem is what she said to Judge Vandenberg last week, and I believe what she believes, is that when something gets rescinded, she is allowed to live there until she finds a new place. And that is not the law. We are more than happy to rescind this, to do away with this contract, let her pay her balance through the date of move out and terminate this contract so that she can move on and we can move on. But what we can't let her do is to live there forever without paying rent.
Well, let it show that by law, by contract law, if the breach is on your end, if you want to comply to it, like I said, because I did rescind it, and the breach was on your end, and it's rebutted on your end. And by law, under the landlord and tenant, it is called constructive possession. When you are in breach of a contract and I'm not at fault, I am allowed under equity and law to stay in a place. It's called constructive possession. Constructive possession. The breach is not on my end. It was on your end.
Miss Battle, that's not the law, ma'am. That is not the law. Absolutely not at all. And ma'am.
Okay, so then if that's the case, if he wants to call out the breach of contract, then he's making it an uneven deal. Okay? So if he wants to say that he wants to accept the breach, then he has to accept the damages that come behind it. Because there's damages if I have to relocate on something that's not based on me. That's unfair. And that is that's unfair in bad faith.
Your Honor, I'm not trying to be unfair. All I'm trying to say
the breach is not on me. The breach isn't on me. So if the breach is on me, I will understand what you're saying completely. The breach is not on me, so I should not be held liable for y'all breach.
Yeah, but you're the one that wants to, Your Honor, but she is the one that wants to rescind. So it seems to me that she can't have.
I want to rescind based on the unconscionable contract. And what does my rescission also say? If it says it, if that's the case, if you all want me to leave and you don't want me to have the constructive possession, then you ought to be paying for my relocation because it was your injury to me.
Can I say something without being interrupted, please?
I want you both to stop talking for a minute, please.
Go ahead, I'm sorry.
So, first of all, if you want to talk about whether a contract can be rescinded, that is not typically what happens in a landlord-tenant. That's in a standard contract situation. However, if there is, in fact, a situation where capital is for you to get some of your monies back. That's not something where you get to just rescind the contract. That's why all of this is the wrong procedure. However, Mr.
I'm sorry.
Please. Mr. Fantera.
You were saying something about getting your money. I need you to go back a little bit. It's breaking up really, really bad.
So you're entitled,
I can't hear you clearly.
if in fact the court were to find that, for instance, the property was not habitable, like there were enough repairs that were done so that the property was habitable. We're not going to be able to make this out with the children in the back. My reporter is saying she can't make it out.
I'm trying to make it out too, and it's just like breaking up a little bit. That's why I tried to tell y'all that this was not like a good time for me at all. Remember, you had got his time, and when I went to go say my time, you cut my mic off, and I was literally trying to tell you that I cannot. It's 3 o'clock. This is not a good time. I'm getting my kids out of school. I don't have help when it comes to getting my kids out of school. So, yeah, but we can continue to try. We can just try to go for a morning time. I can do morning time.
I have on the mornings. You don't have to figure this out. And if you don't figure it out, then the repercussions will be against you. You're gonna have to figure it out.
Well, hold on. I am trying to figure it out. I wouldn't be here if I wasn't trying to figure it out, or if I wasn't trying to, you know.
I grant you that. I agree that I agree with that. But I have criminal dockets every morning. We don't have morning docket.
You said what about a warning? Hey, stop. Hey. You said what about a warning?
I said we have criminal dockets in the morning, ma'am. Is what I said.
Yeah, I can do it in the morning.
That's not what I said.
Oh, I'm sorry. I'm sorry.
Hold on.
Hello? Y'all can't be that loud. No, hush. Leah, for real.
Mr. Fantera, this is not working. It can't be recorded properly because of the background noise. I can't finish this today. Are you available on the 16th at 9 in the morning?
I am, make sure my witnesses are Dawn.
Yep.
Ms. Battle, are you available at 9 in the morning on February 16th?
May 16th, Your Honor.
May 16th. I'm sorry, I'm discombobulated.
Yes, 9
a.m. works?
Yes, 9 a.m. is perfect.
16th at 9. We'll be back here again.
Your Honor, can we require, since I asked before and you said you didn't give notice, her to be by video Zoom?
Yes, Ms. Battle, can you come via video Zoom, please? Ms. Battle, you're muted.
I'm sorry. I keep trying to mute it because I think that's why I keep muting me because of my background. But I say yes, that's fine.
Okay, thank you. I appreciate it.
And I will also mail copies of all of the exhibits that I submitted to the court to Ms. Battle so that she has them beforehand.
Thank you. We'll see you all.
I appreciate it, David.
See you all May 16th at 9 a.m.
Okay. Thank you.
I'm not threatening you. Say one more word and that's 30 days. 30 days.